Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, hey there, everyone. Welcome to another episode of this special series from the Federal Newswire's Lunch Hour, our REINS Act in Focus series. I'm Andrew Langer, your host. Joining us today for this episode is an old colleague of mine. His name is Jonathan Adler. He is the incoming Tazewell Taylor Professor of Law at the William & Mary Law School. So glad he can join us here. And Jonathan, listen, someone who I learned a great deal from about regulation and about regulatory costs. Why don't you give us your perspective on the REINS Act, if it's important, why it's important, and why now?
Well, I definitely think it's an important idea. It's an idea that time is actually long overdue. The basic idea of the REINS Act is that the major legislative type policy decisions about regulation should be made by the legislature. And not by agencies, and that the people that we vote on should ultimately be responsible for making those choices. It also still allows for agencies to have expertise, to utilize their expertise, for Congress to rely upon that expertise, but vests the ultimate judgment about whether or not there should be a certain limit on a certain type of air pollution, or whether or not certain types of economic arrangements should be allowed, or what the rules should be for extending certain types of credit, or you name it. Those choices would ultimately still rest in Congress. And so it's an old idea. It's an idea that's been around for 50 years. But given the size and scope of the regulatory state, given the magnitude of some of the regulatory decisions that we get, given that these decisions ping pong back and forth every time we have a new administration, it's really, in my view, time to have these decisions ultimately made by the legislature. And a REINS Act type measure is really the most practical way of doing that.
One of the things that I've always appreciated about your writing and the writings of some of your colleagues in the legal community at places like the Volokh Conspiracy is this healthy and important skepticism of concentrated power in the federal executive branch. And with that in mind, one of the expressions of that concentrated power is the cost of federal regulations. And when you add regulations that will seem to add that cost by $100 million a year or more, that seems to be an expression of that power. Talk about the REINS Act as an accountability tool in that regard, and about the dangers of increased power, concentrated power in the executive branch.
Sure. Well, so start with the concentrated power concern. The problem is right now is that once Congress delegates power to agencies to issue regulations, it's very hard for Congress to take that power back because of things like the filibuster, because of the obstacles, the so-called veto gates in the legislative process that make it difficult for Congress to enact new legislation to undo a prior delegation. And so you then shift the power to initiate broad policymaking from the legislative branch to the executive branch. And over time, the legislature's ability to make these judgments atrophies. I think we've seen that with Congress being less involved. And the executive branch engages in what I refer to as pouring new wine out of old bottles, finding old statutes that are laying around and figuring out how those old statutes can be deployed to do something new. The way I kind of view it is, it's like when I'm upstairs and I've got a wrench, and I realize what I really need is a hammer. I confess, I'm sometimes lazy. I don't want to go all the way down to the basement to my toolbox to find the hammer. So I figure if I take the wrench and I angle it just right, I might be able to drive a nail and not whack my finger, and it might do the trick. Well, that's what agencies are often doing. They're like, we really should have a hammer, but we don't really want to ask Congress for the hammer. So we're just going to see if we can use this wrench and make do. And we saw that with COVID policy. We've seen that with climate policy. We see this with policy areas across the board, where the agencies just pick up these tools that were given to them decades ago that were intended for some other purpose and try and use it. And so that's a dramatic shift in power that I think is important.
But to be fair, right, Congress bears a great deal of culpability. I mean, I should say, it shouldn't have been surprising to me that in the wake of the Loper Bright and relentless decisions of last year, one of the immediate reactions from some folks in Congress was to issue something or offer something called the Stop Corporate Capture Act, which was aimed to push that power back into the federal executive branch agencies. In many instances, Congress doesn't want to do it. Certainly, we see this with the lack of use of the Congressional Review Act over the years. Talk about Congress's culpability here and why this would force a return to, first principles in some ways.
Yeah.
Please.
Congress is very culpable, right? Because Congress has delegated this power. Congress doesn't legislate with the regularity that it used to. So, for example, when we were at CEI, 20 years ago, more than that, in the 1990s, major statutes were reauthorized on a regular basis, right? Yeah. So the Clean Air Act, Clean Water Act, and so on. And so Congress understood that when statutory authorization expired, it had to revisit these statutes. They had to vote up or down on various reforms or so on. And that was a healthy legislative process. Not that it always produced legislation that I like or somebody else likes, but there was accountability because Congress had to take the votes, had to take responsibility. Most major environmental statutes have not been reauthorized this century, and we can phenomenon across a wide range of issue areas. So one of the key things about the REINS Act is it basically says Congress is going to have to vote up or down on these large policy proposals. We're going to deactivate the normal means of obstruction. This isn't some newfangled or crazy idea. We do this with trade policy all the time. We did this with the base closure commissions. We've done this in other contexts. So it's a tool that Congress has used before. So that members of Congress have to decide, okay, the EPA wants to impose greenhouse gas emission controls on power plants. Is that a good idea or a bad idea? Here's how EPA wants to do it. And Congress votes up or down on that proposal, just like it would with, say, something like a trade proposal under Fast Track Trade Authority. Requiring those votes, requiring members of Congress to say, all else equal, this proposal is either a good idea or a bad idea, is something that would restore accountability and get Congress back in the habit of legislating and taking responsibility for these decisions. I also think it would encourage dialogue between the executive branch and Congress, because the EPA doesn't want to spend months developing a proposal that Congress is going to vote down. And so you would actually get more cooperation between the executive branch and the legislative branch, because the executive branch, instead of worrying about getting things through judicial review, will be focused on how do we satisfy a majority in the legislative branch. And I think overall that would encourage more healthy policymaking in addition to legislative accountability.
And because you opened it up, this is exactly where I wanted to go with this. It also could have the benefit of, listen, I think it's going to take a long time before we start depoliticizing the various courts, whether it's the Supreme Court or the appeals courts or the district courts. But on the other hand, this could go a long way if you're having greater accountability at Congress, and Congress is actually taking a look at these things and saying yay or nay on the major rules. We wouldn't have to leave it to a politicized Supreme Court or circuit picking or what have you, would we?
Well, I agree with that. It would give the courts less to do in regulatory policy. The courts could focus more on whether or not regulations infringe upon individual rights, whether or not there are procedural protections in the context of enforcement, things like that, things that are kind of in the traditional bailiwick of federal courts, right? Protecting rights, going all the way back to Marbury versus Madison. That's really what courts are supposed to be focused on. And the broader structural questions of what sort of regulation is good and did the agency think about it enough? Well, if that's being taken care of by Congress, then courts won't have to be involved with that. And we won't have this phenomenon that we expect right now, which is every major regulation first has to go through the regulatory process, then has to go through extensive judicial review. That lengthens the policymaking process, and that puts pressure on the courts, because inevitably, if these major policy initiatives are going to live or die in the courts rather than in the legislature, that puts a lot of pressure on the courts. That makes people view the courts in political terms, because the courts are the potential barrier to people's policy initiatives and policy goals.
Yeah, no, that's exactly it. And it just, coming back to this issue of concentrated power and the issue of the politicization of the courts, it seems that there should be enough so that folks, regardless of where you sit on the political spectrum, the partisan process of it, they should be a closer examination. Folks who are normally skeptical of regulatory reform efforts, maybe they should take a better look at this because it could serve their purposes in terms of assuaging some of their fears of an executive branch run amok.
I think so. I also think, every group, every set of interest groups likes to claim that their agenda is popular.
Yes.
And in our current process, that rarely gets tested. I have my priors. You may have your priors about whether, environmental regulations or financial regulations or something else would in fact make it through Congress or not.
Right.
But right now we don't know because everybody gets to posture. Because
Yes.
nobody actually has to take the vote. And I think that if certain quote unquote progressive policy initiatives are in fact popular, then they will get through this process. If they're not, they won't. And if it turns out that members of Congress are really out of step with what the people want in terms of broader regulatory policy, there will be a greater ability to hold those members of Congress accountable and perhaps even replace them because they won't just have speeches or Twitter feeds or TV interviews. They'll actually have votes.
Right.
And I think that is a way to actually get a policymaking process that's more responsive to what the people want. And admittedly, though, it would make interest groups. It would test their claims about the popularity of their initiatives. And I am sure that there are some things that I like that would get through this sort of process. I'm sure there are other things that I don't like that would get through, but it would be a more politically responsive process.
Right, and more of a return to the principles that make the republic what it is. Jonathan, your time. I know your time is limited. You're in the midst of a move here, and we are grateful that you've taken the time here. How do folks find out more about the good work that you're doing, the good writing that you are creating as the incoming Tazewell Taylor Professor of Law at William & Mary Law School?
Well, as you noted earlier, I blog regularly at a blog called The Volokh Conspiracy, which is hosted at reason.com. It's an independent blog that with a range of contributors on legal issues. And I also write a column for the Civitas Institute for their online publication, the Civitas Outlook. I think I have one up this morning on the Supreme Court's recent NEPA decision. Those are two good places to look for those that are more academically oriented. I have an SSRN page that lists my working papers and law review articles.
All good stuff. Jonathan Adler, so glad you could join us today.
My pleasure.
Well, this has been yet another episode in the Federal Newswire Lunch Hour's ongoing special series, REINS Act in Focus. I'm your host, Andrew Langer. Enjoy the rest of your lunch.